Appropriation 2009-10 Financial Review Bill, third reading.
I declare the House and Committee for further... I call on order, Government Order of the Day number 2.
Marine and Coastal Area, Takutai Moana Bill, committee stage continued.
I declare the House and Committee for further consideration of the Marine and Coastal Area Takutai Moana Bill.
Mr. Chairman. Mr. Speaker.
Mr. Chairman.
Members, I feel someone should say Groundhog Day.
Groundhog Day.
Members, the House is in committee for the further consideration of the Marine and Coastal Area Takutai Moana Bill. Members, when we last considered the bill, the debate on Clause 1 and 2 was in progress. The Honourable John Boscawen had the call and has 1 minute and 52 seconds. Before I call the Honourable John Boscawen, I need to advise of a vote correction. The result of the vote on Wednesday on the question of Hilary Calvert's amendment to Clause 37 bracket 2 to omit 38 to 44 and substitute 38 to 44 or to local authorities was incorrectly announced as ayes 4s and noes 114. The correct result is ayes 5 and the noes 114. The record will be so corrected. Member, the Honourable John Boscawen would like to take the call. I'll recognise him.
Thank you, Mr. Speaker.
Call the Honourable John Boscawen. Point of order.
Could I have clarification as to whether that's
David
because a vote has been corrected or there was an addition error which meant that there was an adding error that got 4 wrong rather than 5, please?
Well, I can't tell the member precisely how the error occurred, but the clerk's office has advised me there was an error, either in the way in which it was added, whatever it is, but the advice is the vote is incorrect and the vote needs to be corrected. And it has been corrected.
Point of order, Mr. Speaker. I would have thought the House is entitled to know whether it was a party correcting its vote or whether it was an addition error.
Okay, I advise the member this. If a party had called incorrectly their voting numbers, it would have then been the responsibility of the party to seek leave of the House and correct the vote. That was not the case. So, by deduction, the member is entitled to come to the conclusion that it was, in fact, an arithmetical error. No leave was so sought.
Excellent rule. Excellent rule.
Okay.
Mr. Speaker.
I call the Honourable John Boscawen.
Thank you, Mr. Chair. We're back, as you say, on Groundhog Day debating the last debatable motion or debatable question, sir, in the committee stage of this bill. And, of course, we're debating clauses 1 and 2, the title and commencement date. And, sir, I'd like to speak perhaps to the amendment of my colleague Hilary Calvert, where she suggests that this bill might be renamed the Marine and Coastal Area Secret Deals Behind Closed Doors Without Public Scrutiny Bill. Or simply, sir, the Removal of Public Security Act, Scrutiny Act 2001, or the Secret Deals Act 2001, sir. Alternatively, sir, she could have actually chosen to move in another amendment, was perhaps the Marine and Coastal Area Lost Opportunities Bill, Mr. Chair. And the reason I say lost opportunities, Mr. Chair, is because it amazes me the number of government members who have actually said over the last 6 months the Labor Party made a mistake. The Labor Party made a mistake within hours of the appeal court making its decision known in 2003. Helen Clark walked in where angels feared to tread and decided she was going to legislate. And as a consequence, sir, ever since that time, iwi and Hapu feel, sir, that they've had their rights taken from them. They've been denied their day in court. And so what has been the National Party and the Maori Party's response to do that, sir? Well, it seems to me, sir, the most basic response and the correct response, sir, to do that would have been to correct Helen Clark's mistake and simply repeal the Foreshore and Seabed Act. The Maori Party campaigned in the 2008 general election, Mr. Chair, 2005 general election, on repealing the 2004 Act, sir. And it seems to me, sir, that if that is what had happened, we wouldn't have had the hikoi marching on Wellington today, sir. Sir, Mr. Chair.
The Honourable John Boscawen.
Thank you, Mr. Chair. And so what has happened, while the Attorney-General thinks he is doing what is best for New Zealanders, sir, the problem with this solution, sir, is we still have a group, sir, of New Zealanders who feel as though their property has been confiscated. They have been denied the right to have their day in court, sir. And the only way, sir, to correct that, sir, was to ensure that the 2004 Act was repealed, full stop. But, sir, what this bill does is it takes fright. The National Party is taking fright just as the Labour Party took fright, sir, in 2003, because they weren't happy for iwi and hapu to have their day in court. They wanted to set down, sir, a number of tests. They wanted to set down, if you like, sir, the rules. And so the Attorney-General talks about the importance of British common law, the courts interpreting common law, but in this bill, sir, he's actually denying the courts the right to actually do that. He's actually setting down the tests, sir. And, sir, in setting down those tests, the ACT Party, sir, believes that he is lowering the bar. We believe, sir, that there are likely to be large areas of New Zealand that are transferred to iwi and hapu at the expense of other New Zealanders, sir, that otherwise wouldn't be transferred at a cost, sir, to other New Zealanders, sir. Equally, sir, we believe that there may well be some iwi and hapu, sir, who are denied the right to have their court, are denied the right, sir, to get what would be lawfully theirs, sir. And so this is not the correct solution. The government, sir, has taken fright. And, sir, not only has the government taken fright, sir, it has actually misled New Zealanders. I was at a debate last night, Mr Chair, at the Remuera Rotary Club, sir, with a gentleman who sits alongside Mr Chair, the Honourable Chris Finlayson. And the members of the Remuera Rotary Club invited us to debate this particular issue. And it's a tragedy, Mr Chair, that some of the misinformation coming from the National Party was repeated last night, sir, at that function. Sir, I refer to the continual reference to the need to prove continuous and exclusive occupation. The National Party time and time again say, sir, you need to show continued and exclusive occupation of an area to gain customary title, sir. That is not the case. That is not the case. The Attorney-General knows, Mr Chair, that there are provisions in this very bill that say it's quite acceptable for other New Zealanders who have fished in a particular area, quite acceptable for other New Zealanders to boated through a particular area, quite acceptable for iwi and hapu not to have had exclusive occupation since 1840, but nevertheless, sir, we're going to continue and we're going to maintain the charade, sir, that they have. Sir, I raised with the Attorney-General at question time today the issue of access to beaches. When the Attorney-General was asked a question about access to beaches at the Rotary Club last night, he said no, he didn't believe Waihi Tapu would prevent people from walking over an area of the common marine and coastal area, or the members of the Rotary Club, sir, would regard as a beach. And I actually had to stand up and point out to members of the Rotary Club that despite the assurance of the Attorney-General, they only had to look to clause 27.2, sir, where it made it absolutely clear that the rights of free access are subject to the rights of Waihi Tapu. There, sir, in black and white. But I also said to the members of the Rotary Club when I was asked, the reason that this bill is being passed, because most New Zealanders don't understand it. Most New Zealanders, sir, have had a guts full of debating this issue over the last 7 years. It has gone over their heads, and so the National Party is pushing this bill, sir, through this House, and I suspect it will pass its final committee stage tonight, Mr Chair, because most New Zealanders haven't taken the trouble to find out the provisions of this bill, sir, or they've been happy to accept what in our view, sir, are the incorrect assurances of the National Party, Mr Chair. And I think that's a tragedy, because eventually, sir, those New Zealanders are going to wake up and they're going to actually understand the full provisions of this bill, Mr Chair. It's a simple enough issue as that. If more people, sir, had become aware of the provisions, sir, if the provisions had not been misrepresented, sir, I believe that we'd have a much bigger uproar than what we have, and I don't believe, sir, that this bill will be passed through the House. Sir, one only has to go to the document setting the record straight on the Beehive website that a member of that very Rotary Club referred to last night. And as I said before in this committee stages, sir, there it is down the bottom. The government accuses a group such as the Coastal Coalition to be spreading misleading information, whereas in actual fact it's the government. Thank you, Mr Chair.
I call Kelvin Davis.
Thank you, Mr. Chair.